Hello and welcome to this talk about employment tribunal proceedings. My name is Declan O'Dempsey. I'm a barrister at Solicitors Chambers, and in this talk I'm going to be considering hearings. I want first to talk about preliminary hearings. These are hearings that allow the tribunal to conduct preliminary consideration of a claim with the parties present and to make a case management order. Now, these orders can include orders relating to the conduct of the final hearing, so it's really important to come well prepared for those sorts of preliminary hearings. It's also important that before you get to this type of hearing, you should have drawn up a list of the issues that you think that the final hearing is going to have to determine. Make a list of them. The other thing that a preliminary hearing can do is to determine a preliminary issue. Now, this means any issue in anything that can be brought as a distinct legal claim before the tribunal. So it can deal with only part of the whole group of claims brought by the claimant. A preliminary issue is any substantive issue which may determine liability. So this, for example, would be an issue as to jurisdiction. Was the claimant working under an unlawful contract, for example? Was the claimant dismissed? Or any other jurisdictional matter? Was the claim brought out of time? Because if the claimant loses on any of those points, the part of the claim to which that issue relates will fall. It'll be finished. Next, the tribunal in a preliminary hearing can consider whether any claim or response or any part of it should be struck out under Rule 37 for non-compliance, for example. It can also consider whether or not to make a deposit order. Finally, it can explore the possibility of settlement or alternative dispute resolution, including judicial mediation, at one of these preliminary hearings. Remember, it cannot compel the parties to enter into settlement or into alternative dispute resolution. There may be more than one preliminary hearing in any case, but for cost and proportionality reasons, you'll probably want to have as few of these as possible. When should preliminary hearings take place? Well, the tribunal can direct that there should be one following the initial consideration of the claims, which happens in all claims. Secondly, the tribunal has a general power to direct one at any time. Thirdly, the tribunal may agree to have one after a party makes an application. But everybody has to get reasonable notice of the preliminary hearing, no matter what the content of the preliminary hearing is to be. However, if a preliminary issue is involved, there has to be at least 14 days notice of the hearing, and the notice must be specific about the preliminary issues that are or may be decided at the hearing. Remember that the preliminary issue is any substantive issue which may determine liability. So it's not necessary to give 14 days notice of a strikeout, a case management order type hearing, or a deposit order type hearing, or a hearing at which ADR is going to be promoted. The employment judge sitting alone will hear the preliminary hearing, but you can ask in writing for a full tribunal if notice has been given that a preliminary issue will be decided or may be decided at the hearing. However, the judge then decides if that course of action is desirable. Now, it's more likely that you'll get a full tribunal if there are a lot of facts to be determined or if it depends on questions of industrial practice. Generally speaking, these hearings are held in private unless they're determining a preliminary issue, or they're considering whether a claim or response should be struck out. In either case, then, any part of the preliminary hearing, which relates to those matters, has to be heard in public. However, if the rules on privacy, which deal with the protection of identity, restricted reporting orders, and the times when you can have evidence in private apply, then the hearing can be in private too. In addition, if national security is involved, it can be held in private. The tribunal also can direct that the entirety of the proceedings should be in public. I want to turn now to final hearings. This is a hearing where the tribunal decides the claim or whatever's left after the initial consideration or preliminary hearing. Now, the rules say that there can be different final hearings for different issues. What they mean by that is this: you can have a hearing that's devoted solely to liability. This means that the tribunal establishes whether the legal wrong has been committed and whether the respondent's liable or not for any remedies, but it doesn't determine the remedies. You can have a hearing on remedies. There, the tribunal establishes the proper remedy, so for example a declaration, reinstatement, re-engagement, making a recommendation, or compensation. Very often it's not determined at the same time as liability, but it can be, and it's important to establish what is going on in your case and prepare accordingly. And you can do that as early as you can when the notice of hearing comes out to you. Finally, the rules also suggest that there can be a separate hearing on costs. It gives it as an example of a different issue on which there can be a different final hearing. So there can be separate hearings on costs, preparation times, wasted costs, expenses. Often these have been dealt with at the end of hearings. A question arises concerning the rules on the amount of notice you must receive of a final hearing. Rule 59 says any final hearing must be in public, but that's subject to the rules about privacy and national security that we've looked at. I want to turn next, though, to the provisions relating to notice of final hearings, because you have to get 14 days notice of the date of the final hearing from the tribunal. Now, 14 days notice of the date of the final hearing has to be calculated in terms of what the rules provide. And if you have a look at another one of the talks that I've done, you'll be able to see how you calculate these time periods. If notice isn't given that an issue is going to be dealt with at the final hearing, suppose the hearing notice simply gives 14 days notice of a final hearing, but it doesn't say that it'll deal with liability, or it doesn't say that it'll deal with liability and compensation, or suppose it doesn't say that it'll deal with liability, compensation and costs. What are the consequences of that formulation of the notice? Well, if the document simply says that there will be a final hearing, then it's arguable that anything that's contained within the claim or the response, which is still left after the initial consideration and preliminary hearings, will be determined at the final hearing. It's the hearing at which the tribunal determines the claim, and Rule 1 says that the claim means any proceedings before an employment tribunal making a complaint. The term complaint includes an application in any enactment which confers jurisdiction. So the question then arises whether it's necessary that a claim for costs should be spelt out in a claim, and if it is, will the tribunal need to give 14 days notice of the final hearing concerning costs? The tribunal can only exercise its power to award costs either on application or of its own motion. I think the solution to this is that if either party was placed at a serious disadvantage by not knowing that there was a possibility that costs could be dealt with, because, for example, the notice confined the hearing to liability only, then either party that's been disadvantaged might be able to appeal. I want to turn briefly to the concepts of decisions and reasons. If a decision is made without a hearing, it must be communicated in writing to the parties, and it's got to identify the employment judge who made it. So have a look at the document that sends the decision to you. A decision can either be reserved or announced at the end of the hearing. If it's reserved, it has to be sent in writing to the parties as soon as practicable. If it's announced, then a written record, e.g. a judgment, will be provided to the parties, and if the matter has been referred from a court, it will be sent to any referring court. But note this, decisions concerned only with the conduct of a hearing don't need to be identified in the record of that hearing unless you ask that a specific decision is recorded in this way. So if you want that to happen, then ask, please could you record the decision concerning whatever the issue is in your judgment. And you might want to add after that under Rule 61(2) of the rules. The written record has to be signed by the employment judge, save in certain situations which we're going to come to later on concerning absence. Reasons. The tribunal's got to give reasons about any substantial or procedural issue which is in dispute. So you have to work out what matters are in dispute before you get to the hearing and ask the tribunal to determine those issues. The tribunal then has to give reasons for its decision about those matters that are in dispute. If the decision is in writing, then the reasons must be. However, if the decision was announced, then it can be accompanied by orally delivered reasons, or the tribunal can reserve the reasons and send them in writing later on. Written reasons have to be signed by the employment judge, so that if the reasons are announced orally, be careful. Under the rules, Rule 62, the employment judge has to say that the written reasons will not be provided unless they're asked for at the hearing itself or within 14 days of the sending of the written record of the decision. So if you want written reasons, remember to ask for them, either orally at the hearing, which is probably easiest, or in writing, but you've got 14 days from the sending of the written record. Have a look at the provisions relating to the calculation of time to work out how long that period actually is, in order to ask for them. So when you get a written decision, it should repeat that written reasons won't be provided unless you ask for them within 14 days. If you don't ask, then the written reasons will only be supplied if the appeal tribunal, or for example the Court of Appeal or a court, asks for them. Note this also, that Rule 62(4) says that the reasons for any decision shall be proportionate to the significance of the issue, and for decisions other than judgments may be very short. So an appeal tribunal is likely to be not very sympathetic to the idea that insufficient reasons have been given for anything which isn't a judgment. But of course it will depend on the proportionality of the significance of the issue in the case. Looking at judgments, the tribunal has to provide it must identify the issues which it has determined, so that's why it's important to identify the issues that you're asking it to determine. State the findings of fact made in relation to those issues, concisely identify the relevant law, and state how the law has been applied to those findings in order to determine the issues. If there's a financial remedy, it's got to identify how the amount to be paid has been calculated. Now, you've got to be able to understand why you've won or lost as a minimum requirement for reasons. But the appeal tribunal judges that objectively. It uses its own judgment and asks whether a reasonable person would understand whether they've won or lost on the basis of the reasons given. If you agree you can have a consent order. So the parties can ask for a judgment or order by consent. If the tribunal agrees to make it, then it identifies that it's been done by consent. I said that there were special circumstances when somebody else can sign the written record. Well, if the judge is dead, sick or absent, the other members of the panel can sign it, or in default the president, vice president or a regional employment judge if the employment judge was originally sitting alone. Judgments take effect from the day on which the judgment is given, or any later date which is specified by the tribunal. And there's a compliance date of 14 days of the judgment unless the judgment specifies a different compliance date, or if the tribunal assisted or stayed the proceedings or the judgment. Copies of the judgment and reasons go onto the public register, subject to the rules about privacy and national security, and if a court referred the proceedings, they get a copy of the judgment and reasons. At any time, an employment judge can correct clerical mistakes or other accidental slips or omissions in any order, judgment, or other ET document. The published version of the document gets corrected as well, and the corrected version is sent to the parties and it's signed by the employment judge. I want to turn next to reconsideration, because a tribunal can, on its own initiative, perhaps after it's been asked to do this by the Employment Appeal Tribunal, or because the parties applied for this, reconsider any judgment if it considers that it's in the interests of justice. If it reconsiders, it can either confirm, revoke, or vary. If it revokes, it is entitled to take the judgment again. How do you go about applying for a reconsideration? Well, the first way is to apply orally in the course of a hearing. Otherwise, you've got to present your request in writing and copy it to all the parties within 14 days of the date on which the written record or written communication of the original decision was sent to the parties, or within 14 days the written reasons were sent, if that's later. You've got to set out why reconsideration of the original decision is necessary, so therefore you should set out in detail your reasons why it's in the interests of justice that there should be reconsideration. If the tribunal reconsiders the matter on its own initiative, it's got to tell the parties why it's doing this, and then it proceeds to reconsider, going straight away to the phase of the procedure we're about to have a look at, in which the original or substitute decision makers consider whether or not the original decision should be confirmed, varied, or revoked. So this is the procedure when reconsideration is asked for. The original deciding or chairing employment judge, so the one who's made the original decision or chaired the panel, asks whether the application has any reasonable prospect of success. So in other words, the judge will ask, is there any reasonable prospect of the original decision being varied or revoked? This includes looking at whether there's been a substantially similar application in this case, on this point, which has failed. If either of those are the case, then the application is rejected and the parties are told this. If neither of those is the case, then the tribunal sends notice to the parties, giving a time limit for response to the application, and it seeks the views of the parties on whether the application can be determined without a hearing. Now, the employment judge may set out his or her provisional views in this notification, so pay particular attention to them. If the application for reconsideration is not refused in this way, then it's considered at a hearing unless the judge thinks that one's not necessary, but the judge can only do that having considered the parties' representations. Parties are then given a further reasonable opportunity to make further written representations if there's not going to be a hearing. Now, the original employment judge who decided the point, or the original full panel which decided the point, will deal with this hearing. However, if they're not available, either all of them or some of them, then the President, Vice President, or Regional Employment Judge appoints another employment judge if it was an employment judge's original decision, or tribunal panel members essentially to bring the panel up to strength. The panel can be completely replaced if it's appropriate to do so by the President, Vice President, or Regional Employment Judge, but that is only if the original panel is not available.